coming to you live and direct because I need you to see my face on tonight's class. There are a lot of things that I want to cover, especially concerning some of the things that we have already went over. All right? Now, the reason I want to do this live is because there are particular documents that I want to show you because not everything should be digital, okay? You have to maintain master copies, all right? There's a particular reason for that. But tonight's class, as if we were in last week's class when we were talking about enumerated rights, we were talking about our Ninth Amendment, we were talking about our liberties and our remedies, okay? So tonight's class, I'm going to further finish that up. We're going to go into these privileges and these immunities in the clause of that. We're going to go into full faith and full credit clause as well, because those two are saying the same thing, but it ain't for the same kind of people, okay? You either get privileges, you accept the privileges, or you come in with your own credit and your own faith and your own jurisdiction. It's really just that simple there, all right? Like we are seeing, I am noticing it's a lot going on in time and space right now, coming to a lot of these organizations, and there's a lot of people sitting there saying, yeah, y'all just a bunch of niggas running around with feathers on. You just a bunch of niggas, you is to be independent, accepting privileges instead of coming with full faith and full credit, okay? But you wouldn't know about full faith and full credit if you just going over here being a la carte. You being an a la carte Moore. You being an a la carte American national. And that's what happens. This process is a transition. It is not a process to pick and choose what you want to put on your plate. You're going to have to eat all this and some more, and then come back and get some dessert. So when we're having particular situations where that is happening, well, you know, how much can we blame another organization because you decided that you didn't want to do your own due diligence and figure out what your liberties and remedies are? Because when you give into the spectrum of knowing what full faith and full credit is, then you start to see that this is business. It is not serious. It is not personal. None of it is personal. And so we're going to go into these particular topics until you actually get a clear insight that this is business. Only people that's making it personal is you. Only person that's having issues with the flow of information is the person that is not doing the due diligence to carry out, to get their pursuit of liberties and remedies, okay? And so I'm going to show y'all some documents. I'm going to take y'all off mute in a second. If you got any questions pertaining to where you are, we will definitely rectify that at the end of the video, right? So we're going to do all that good stuff. But right now, I want to actually show you that y'all are just at the beginning. Okay, and if we can't get to the concept of which way we are getting our full remedy and our full credit enforced and not going after privileges and immunities, there are certain things that are a privilege and immunity, and you need to know if you're going to accept this privilege and you're going to contract, you need to know how to contract, okay, because this is all contracting. This is when you become a contractor. So, and that is a very important on why you guys are going to learn how to do that administrative procedure. Because in reality, I tell you, from day one, everything is an administrative procedure, okay? Everything. And if you do your administrative procedure, they will tell you everything else that you need to complete that presentment. And that's just word, okay? Now, the particular subjects that we are talking about is going to be dealing with, of course, jurisdiction. It's going to be dealing with, of course, remedies. It's going to be dealing with liberties, okay, in a certain way that you would go about making sure that you're enforcing these remedies. Because that's the problem. The problem is that we know that there's remedy, but we're enforcing it as if we're a dependent accepting privileges. Okay? That's where it's wrong. Y'all are going to get what I'm saying when we go further into this scenario. All right? So, in essence, right now, this is really a value to what your collection is. This is your secure creditor. You know, it's an entity. You need to make sure that you're keeping minutes and you're keeping all of your documents organized. Okay? This is the particular person that we are working on now is the one that has full credit. Not the particular who has full faith. This is the particular who has full credit. Okay? This is the particular entity that you are doing commerce with. This is the individual that walks on water, does not drown in debt, okay? So therefore, we do not have to accept handouts or hand-ups out of debt when we are the credit, all right? So we not, you didn't know. We is not going to Lamu and Maxim and going to be sitting there having testimonies about just because, come on, let's just be real. A lot of y'all up in here is some refugees for some other organizations that's talking crazy and they ain't got no remedy. Because I'm going to be real with you. All y'all talking about all this stuff, but y'all ain't busting no bonds, though. Y'all ain't busting no bonds, though. We could sit and talk for 20 years about particular things. Why am I still teaching 20 years from now? Like, shouldn't I be off on the island because you ain't busting no bonds? So, dead all of that, okay? You don't go to a particular organization and expect everything to just be it doesn't work that way. It will never work that way. I hate to break it to you, but it won't, because it takes a lot of correlating information to even get to, looking at my shoes, to even get to understanding what we're doing, okay? So now, let's just get back to this. Tier 1. Nationality. All right. This folder right here goes just to tier 2. Okay. And this is all the documentation. You see how thick that is? This is just tier 2. Once you get to tier 2, now you got more privileges in lieu of being a creditor. That's what we are. Okay. We are in a different reality right now. We are in a reality where we can get remedy if you decide to stay the course of getting remedy. All right? There is a lot of equity that goes into getting said remedy. And that's where we are right now. And so we are going to talk about, we're going to do some reading. I'm going to cancel this class out at 9:30. Taj, keep me on point with that, with the 15-minute before marker. And we're going to get into basically this 14th Amendment, which is the Privileges and Immunity Clause. Here's a scenario of you accepting a privilege. You said, and you went through this process, and you have said that you are an American national, but then you turn around and you open up an African American, American Indian, disadvantaged, woman-owned minority company to get a privilege known as a grant instead of coming in full faith and credit and being a grantor of the grant. That is a privilege. We have to stop doing that. You stop accepting the privileges, then you will be immune. And then you will not be in that tax bracket. Okay? We got to know certain prerequisites when we're dealing with commerce. Approved the clause without controversy. The concept of privileges and immunities meant that colonists were a part of an unratified political community, could travel freely and establish permanent residency in any other colonies, received certain legal rights and were guaranteed access to courts, and were able to sell their goods in other colonies. Before independence, the Declaration and Resolves of 1774 outlined several natural rights of the colonists, including the right of life, liberty, and property. The delegates to the First Continental Congress distinguished between natural rights and privileges and immunities. Say what? Natural rights and privileges and immunities, describing that the latter as positive rights granted by royal charter or provincial law. The Articles of Confederation contained a clause protecting the privileges and immunities of citizenship. Although revised several times, the final version of the clause created common citizenship, guaranteed freedom of travel, and provided equal protection of the laws by protecting freedom to conduct business. All right, freedom to conduct business is being able to keep it civil. Okay, when you are a civilly dead person, you have lost the right to contract. If you are labeled a felon, didn't they take your ability to contract away from you?
Mm-hmm.
All right? Yep. Now, based on James Madison's objective, the Privileges and Immunity Clause in the Constitution was simplified. It created common citizenship, but Congress still retains power to determine who became citizens. It was also prevented states from discriminating against citizens of other states in judicial processes and economic activities. Many states distinguished between privileges and immunities on one hand and natural rights on the other. The privileges and immunities remain positive rights, positive law. A state could repeal them, and an individual had no right to claim them for himself. Natural rights are not granted by the state. They are inherent in nature of man, and the state only secures them. The Supreme Court held in Cornfield versus Coryell, 1823, the privileges and immunities included natural rights. However, in the Slaughterhouse case of 1773, the court rejected the idea. Okay, so let me go up to cross-reference this. I'm going to post this. This is a dope PDF, by the way. I'm going to post this up. All right. Full faith and credit clause. As James Madison noted, the full faith and credit clause of the Constitution promotes harmony and proper intercourse among the states. Keep it civil. Just keep it civil. Don't be belligerent. Don't be in here acting like a dependent, asking me to pay for shit, and now you want to turn around and think you entitled to something. But you ain't put the work in to even be entitled to even own your name. Next. So, it chiefly unites court systems of different states insofar as it ensures the courts of one state honor the judgments of courts in another state. What? Jurisdiction? The Supreme Court has applied this clause in 3 when one state's courts may take jurisdiction over claims involving another state, determining which state law applies in a case with multi-state disputes, and recognizing and enforcing judgments from another state's court. First, the court has used the full faith and credit clause to require state courts to hear claims that arise under sister state laws. Oh, y'all in treaty? That's what you're doing? Okay. Y'all got like a tri-state thing going on? Tri-state treaty type thing? Oh, what y'all, the 6 nations, the 5 nations, what you is? Or y'all the 13 colonies? What kind of, who treaty with treaty so I get my treaty up and through there? Oh. A state court cannot categorically refuse to hear claims that arise under another state's laws, but it may be exempt from from this requirement if, for instance, it does not recognize the equivalent based on local law. Additionally, a state cannot limit a litigant's option for hearing to its local courts alone. What? A state cannot limit a litigation's options for hearing to its local courts alone. Second, the Supreme Court guidelines requiring the application of a state's laws for a multi-state dispute have varied. At first, the laws of the state where the dispute occurred were applied, even if the trial took place in a different state. But if the state had interest in the case, the state's court could apply its own laws. Today's state court has a decree of discretion regarding which state laws to apply. Third, The Supreme Court has ruled that states must recognize and enforce to the same extent that the deciding state would the decisions of other state courts. There are a few exceptions to the rule relating to personal jurisdictions, deeds of lands, and penal claims. In recent years, questions have emerged about the application of the full faith and full credit clause to issuance of marriage, divorce, and child rearing. For instance, state courts change child support and custody judgments made in another state if these alterations are in the best interest of the child. The Defense of Marriage Act 1996 allows states not to recognize same-sex marriages from other states. Get back to here because now we have a little snippet of what the difference between the two is, okay? Now, back to the 14th Amendment. 14th Amendment addresses many aspects of citizenship and the rights of citizens. The most commonly used and frequently litigated phrase in the amendment is equal protection of laws, which figure prominently in a wide variety of landmark cases, including Brown versus Board of Education, racial discrimination, Woe versus Reid, reproductive rights, Bush versus Gore election recounts, Reed versus Reed, gender discrimination, University of California versus Bakey, racial quotas in education, whatever. Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, or deny any person within its jurisdiction the equal protection of the laws. Representatives shall be apportionated along the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. What? But when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislative thereof, is denied any of the male inhabitants of such state, being 21 years of age and citizens of the United States, and in any way abridged, except for participation in rebellion, being belligerent, or any other crime. All for one, one for all sort of thing going on here. All y'all getting drafted right now. No person shall be a senator or representative in Congress or elect or president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of the Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or giving aid or comfort to the enemies thereof, but Congress may, by vote of 2/3 of each house, remove such disability. Oh, treason. The validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for service in suppressing insurrection or rebellion, shall not be questioned. Say what? Okay. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave. But all such debts, obligations, and claims shall be held illegal and void. The Congress shall have power to enforce by appropriate legislative the provisions of this article. All right. Then as we were sitting here and we were reading this particular document, all right, on privileges. Now, it did say that these these privileges and immunities were afforded to the colonists, known as the Englishmen. So who are the citizens? Because we also just read that this don't apply to no aboriginals, as they AKA call you an Indian, because they tax exempt. Tax exemption is an immunity because it's all about taxes. Everything is dealing with taxes. So if you are an Indian farmer and you approve this 14th Amendment without controversy for the colonists, which are the Englishmen, which are the ones that are promoting common law, which is English law, then they got nothing to do with the farmers. All right. They also said that if you are a citizen, it says only your state can give you citizenship, right? They said that you are a citizen of the United States, and then you also are a citizen of the residing state. But what is the difference in the two? Who can tell me what's the difference in the two, and what it is you're actually trying to accomplish? Because you really just electing one over both. So what does that even mean? You're a citizen of the United States of America, but you're also a citizen of the state of Alabama Republic. How do we fix that? Well, we would fix that when we change things around and we say, I am an American national to you, United States Corporation. And two is when we say, okay, I am a state national of the Alabama Republic in my residing state. Okay? That's why on some documents you will see it says American national, private resident or private citizen of whatever republic that you're in. This is a choice. The thing is that nobody made a selection for you on which side of the fence you wanted to play. So now you're just playing both. They had to snatch you up and claim you as a dependent because nobody else was around to do your elections for you to put you in a proper tax bracket. So I'm going to kick this off, and then we're going to pass. So whoever wants to go, I'm going to read the page. I'll just read 2 pages, and then whoever wants to jump in can take over. So, e pluribus unum. We need to learn some Latin, okay? The full faith and credit clause and meaningful recognition of out-of-state adoptions. Parents and children whose legal relationships derive from state adoption agreements face uncertainty when they travel across state lines. State officials have denied out-of-state adoptive parents revised birth certificates, which recognize their status as legal parents in their child's birth state, because the parents would be statutorily unable to adopt in that state. Various U.S. courts of appeals have disagreed as to whether and to what extent the full faith and credit clause in Article, is that 14 of the no, is that 13 or 14? This 14 of the Constitution requires the state executive officials recognize out-of-state rights. Circuits offer differ as to whether the full faith and credit clause confers an individual right for purpose of 42 U.S.C. subsection 1983 on parents alleging a violation of the clause. The divergent option results from conflicting interpretations of the force and scope of the full faith and credit clause, distinctions between recognition and enforcement of out-of-state rights, and the varying views of the clause's balance of state policy, interest, and federal unity. Now, we've seen how short that 14th Amendment was. We've been through the 13th Amendment. We might need to go through that one again, too, because if you, that 13th Amendment and them 20 sections, you ain't read a 13th Amendment if you ain't got a certified copy from the Library of Congress with the 20 sections that is a party to that 13th Amendment. Otherwise, you're just going to get, this is what it's about. No, We need to know what it says. That's part of your remedy. So we got this one we went through, which is the 14th Amendment, which is where we're talking about the immunities and privileges of the so-said English colonizers, right? All right, so now let's get back over to here. So full faith and credit shall be given in each state to the public acts, record, and judicial proceedings of each other state. And the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime who shall flee from justice or be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up and be removed to the state having jurisdiction of the crime. No person held to service or labor in one state, okay, under the laws thereof escaping into another shall, in consequence of any law or regulation therein, be discharged from such service of labor, but shall be delivered up on claim of the party to whom such deliver or labor may be due. You got a warrant? Where? You're getting extradited. New states may be admitted by the Congress into this union, but new states shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states, without the consent of the legislator of states in concern as well as of the Congress. The Congress shall have power to dispose of and make all needful rules and regulations respecting the authority or other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. The United States shall guarantee to every state in this union a republican form of government, and shall protect each of them against invasion. And on application of the legislator or the executive where the legislator cannot be convened against domestic violence. All right. Now, let's pull this up too, because we talked about this last week in class. The federal question, we were talking about what jurisdiction, what is the argument, okay? The federal question is challenging jurisdiction based off birthright, based off natural right, based off nationality. Okay, let's go back, because then we just get that, get full faith and full credit. Is that not what we just did? Did we not get one of these? Did we read it? What does it say? It says the United States of America, the Department of State. These presents shall come. Greetings. I certify that the document hereunto annexed is under the seal of the state of Minnesota, and that such seal are entitled to full faith and credit. For the contents of the annexed document, the department assumes no responsibility. This certificate is not valid if it is removed or altered in any way whatsoever. That was to certify that she was even eligible to even issue credit. Are you even eligible to issue credit? Yes, she was authorized at the time, so now we can go ahead and charge this up and give you full faith and credit, and you can stop being a dependent, accepting privileges and immunities. Right? So, back to class. Civiliter. Civilly, in a person's civil character or position, or by civil, not criminal process or procedure. This term is used in distinction or opposition to the word criminaliter, criminally to distinguish or disguise civil actions from criminal prosecution. Civiliter mortem, civilly dead, dead in the view of the law. A condition of one who has lost his civil rights and capacities and is accounted dead in the law. All right. Then we went down into the criminal literature. All right. Now, the difference between these two, all right, because we have civiliter, and then we have criminaliter, right? So these are two ways that drop in status. Civiler and civiler over a criminaliter is the difference between was it civil or was it criminal, okay? Now, civilly, you went from a creditor to a debtor. That's civiliter mortuus. You lost your status as being a creditor because you were in your debtor ways, all right? Criminaliter mortuus is you actually went for that shit. You actually accepted the fact that all crimes are not commercial, and that you actually accepted the fact that you didn't know how to change your venue and you didn't know how to maintain your jurisdiction, so therefore they contracted with you. It changed you from a civil individual into a criminal individual. I thought it was in its proven guilty. No, because you black. You already damn guilty. Just being that, you committed a felony. So we're going to take you to jail. And then you are so far beyond in status, we already know that you ain't got no way to pay your bond without being the surety, because we're the creditor. You're the dependent. So no matter which way you juggle around that, you are going to be creditor mortuus. So, civiliter mortuus, civilly dead, one who is considered as if he were naturally dead, so far as his rights are concerned, okay? So, wait a minute. We just said that due to your status, your decrease in status, you know, due to Capitis Demaxius, as what we were just watching in the previous video, we knew that we were already being traded as securities. We now know that the particular ideologies that we voluntarily identify ourselves with, i.e. black, means that we are now voluntarily admitting to being into felonious activities. What is the opposition of these two? Sui juris status, okay? Latin, meaning man, woman of all of their own rights, all of their own liberties, possessing full social and civil rights, not under any legal disability or the power of another or guardianship, having capacity to manage one's own affairs, not under legal disability to act for oneself. Proper personam goes back to the 4 jurisdictions. It's personam jurisdiction, which is your personal jurisdiction. That is your A1 day one, okay? Is your personal space. Who are you allowing in your personal space? Who is in your wallet? Okay? Number 1, personal personam jurisdiction, okay? We're not talking about putting in special appearances. And think about that. Let's think about that, what I just said right there, because we need to debunk some ideologies. I want to put in a special appearance. Who appears? Who makes appearances? Who is summoned to go somewhere?
The dead.
The dead.
Ghost.
The civiler mortuus. The criminaliter mortuus. So we're going to out here tell people how to argue as a ghost? You better learn how to be Casper.
Ghostbusters.
That doesn't even make sense. You know, like, yeah, we got so many 14th Amendment scenarios or You look, don't be a 14th Amendment citizen, but I ain't gonna tell you nothing about your 9th Amendment Constitution. I ain't gonna tell you nothing about your unenumerated rights. I ain't gonna tell you nothing about your unalienable rights, and I damn sure ain't gonna tell you about no jury status. You're putting in a petition. A petition is a prayer, right? It is and it is a claim. That's why when they say, girl, you better pray on it and you better claim it and it's going to happen. So what you did is you took your claim, you submitted your prayer, your petition to the court, which is your God, because they are the ones that are guarding you. You are underneath their governance, right? So you went and you petitioned, you submitted your prayer to redeem yourself, and granted. And the word granted means to convey or to bestow something. So when your name was granted to you, the judge released you from his quarters, released you from his court, and said, okay, I'm going to bestow this estate upon you. It's an offer. Your prayers were answered.
Hallelujah. I'm not the 16.
They were answered, okay? And now you have to accept the contract. That's why you do an accepted certificate of acceptance and acknowledgement of nationality, because it's still an open contract. There's always 3 parts to a contract. All right? So now that you've accepted it, you have claim title over it. I now own this contract. I'm the one that created the contract, and the one that creates the contract is the owner of the contract, right? So we did that. Moving right along. Now we ensure juris status. What do we do, family? What do we do? What do we do? Do we continue to argue as if we did?
No.
So what do we do? Because this is the problem. Yeah, what do we do? Where do we go from here? We're going to go on down to this PDF and we're going to read. That's what we're going to do.
Amen.
Hey, when to hold them, know when to fold them. Chapter 1, the supreme law of the land. So, while discussing law, it is imperative to understand that there are 2 types of law: the law of the land, the law of the water. The law of the land is the common law that the people of a given land abide. I'm getting an echo.
Yeah.
Yeah. Okay, thank you. Okay, peoples. All right. So the law of the land is the common law that the people of a given land abide. In the United States of America, the supreme law of the land is the self-governing people individually. The Declaration of Independence, the Constitution for these United States. Now you see how it's lowercase. Make sure we're paying attention because we're playing with a battle of words, okay? This is spelling. Okay? All right. And the Supreme Court ruling in line with both of those founding documents. Now, those founding documents are instruments of common law. Represent the law of the land. A change in law represents a change in religion. In the United States of America, the supreme law of the land, being the will of self-governing free people, is the Declaration of Independence. The Constitution of these United States of America and the Supreme Court rulings in line with both of those founding documents. Let's highlight that too, the Declaration of Independence. While working on the research for this book, I found it nearly impossible to contemplate law without getting into religion or a God at least a little bit. It doesn't matter what religion specifically an individual follows. Most of them have the same concepts as to the origins of law being from the Word of God and the rights flowing from this same source as well. The common law is biblical law applied, derived from applications of canon and biblical law by the Christian churches in England in the 8th, 9th, 10th, and 11th centuries. It has been proven that 64% of the Constitution is reasoned from statements in Deuteronomy and a commentary upon Deuteronomy. By a seventh-year study conducted by the University of Houston in 1980s, referencing 15,284 sources. This does not seek to favor one faith over another. All faiths are transcended by the ideas that established law. The individual right to the lawful defense of law, freedom, and property. The common law is a direct connection between the Bible and the Constitution. In the state of New York, the common law is embodied within the state constitution, which is also what happens to determine what the county sheriff is the highest constitutional law enforcement officer in the county, with jurisdiction over all municipalities, villages, and townships within the county, as well as those local police departments. This can be verified in the About Us section of the Erie County Sheriff's website, but is self-evident. Every time I refer to common law, I am in fact referring to those founding documents of divine inspiration. The first law is God's law. The law is the individual right to the lawful defense of freedom, property, and life. Crime is the causation of harm to another. There are only three ways anyone can actually break the law or breach the peace. 1, damage or injure person or property. Where is the victim? Where is the victim? Do not harm thy neighbor. Do not do crimes against thy neighbor. Where is the victim? The state is not the victim. Put the state on the stand, because I'd like to know how the state said that I choked the hell out of it. Where is the victim? 2, violate another's lawful rights. Hate crimes. 3, the use of fraud in contracts. All right. With all of this endless sections of uppercase United States Code, the Code of Federal Regulations, lowercase, state laws, ordinance, bylaws, directives, and every statute encoded, it is easy to get confused and overcomplicate matters. In my opinion, the laws of this country have been intentionally overcomplicated to break that beginning principle of everyone being equal under and before the law. The supreme law of the land, the common law, the Declaration of Independence, the Constitution for these United States of America, and Supreme Court rulings is lined within them. Constrict and restrain all other laws, the United States Code, the Code of Federal Regulations, state laws, ordinances, bylaws, directives, and every statute encoded are all children of the common law. A statute may be passed by a legislator and given the form and name of law, but if that statute conflicts with the common law, the supreme law of the land, or if it infringes or violates a lawful right, it is not law, but null and void, unless you consent to the authority of such a statute by your signature, which will be detailed more on later. There are many Supreme Court rulings that enforce this self-evident truth that any item given the form and name of law that is repugnant to the Constitution is void. An unconstitutional act is not law. It confers no rights. It imposes no duties, affords no protection. It creates no office. It is in legal contemplation or inoperative. It has never been passed. Norton versus Shelby County, 118 U.S. 425, page 442. The general rule, constitutional statute, though having the form and the name of the law, in reality, no law, but is wholly void and ineffective for any purpose, since unconstitutionally dates from the time of its enactment, and not merely from the date of the decision so branding it. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. 16th American Jurisprudence, second section, 177, late second section, 256. Now, statutes are not law. All right. All laws which are repugnant to the Constitution are null and void. Finding that the statute conflicted with the federal Constitution, Marshall considered it the essence of judicial duty to follow the Constitution. Federal question. Get back to your federal question. Okay. He concluded that the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to Constitution is void, and that courts as well as other departments are bound by that instrument. Say what? Bound? Bound? Did somebody take an oath to a constitution, to uphold this constitution and these liberties and this Declaration of Independence, and within that was the unenumerated rights of the Ninth Amendment? Can I get a witness?
Yeah.
So what you mean, statutes and codes? All right, let's keep it moving.
Hey, Tiff.
Yeah.
When they give those people those tickets, they're actually trying to sue you.
Well, they actually just arrested your body. If you read the ticket, it says that this ticket is in lieu of your arrest. Like, it's in lieu of taking you to jail. You were arrested.
Right. When people walk away with those tickets, I didn't get arrested. Oh, yes, you did.
Right. And you signed your signature, and you put what you did was a signature bond. That's what you call a signature bond. They let you out on your own recognizances. Okay. So it is, let me see, and that the courts as well as other departments are bound by that instrument. It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislation may alter the Constitution by any ordinary act. Because these alternatives, there is no middle ground. The Constitution is either the superior paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts. And like other acts, it is alterable when the legislative shall please to alter it. If the former part of the alternative be true, then a legislative act contrary to the Constitution is not law. If the latter be true, then written constitutions are absurd attempts on the part of the people to limit the power in its own nature, illimitability. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate. Hold on, stop. Does anyone know what this word means? Abrogate. Say that again. All right, let's check it out. Didn't y'all see it was quite funny? They over there in the UK, over there being chattel property too? And y'all think it's us. All right, abrogate. To nullify a contract by means of mutual agreement. to officially abolish a law. Like what they do. They tried to abrogate your unenumerated rights. They tried to abrogate natural liberties, the pursuit of liberty. Okay, so now, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them.